Welcome to the TMC Newsroom. Rich Tehrani here. Thanks for watching. We're at IT Expo West 2012 in Austin, Texas. And on our program is Chris Douglas. He's an attorney at law at Alston Bird LLP. He is part of our Suits conference, which focuses on telecom and tech patents. And Chris, welcome to the show.
Yeah, thanks, Rich. Glad to be here.
So what's your specialization as a firm? I assume it has something to do with the patent space, right?
We do. We have 900 attorneys across the country, and so we specialize in all areas, tax, business law, all forms of litigation. But I'm here to talk about patent law and intellectual property in general. We do both litigation and preparation and prosecution of patents, and that's why I was asked to join in on this conference.
Well, we're thrilled to have you here, and I'll tell you, one of the most interesting things in my career in covering communications and technology for the past decade plus, couple decades plus, is we seem to be writing more now about patents than we do about technology in the trade press, and it's so important, and especially mobile patents. I'm wondering, do you have any thoughts on what's happening there?
Right. I think what we're seeing is that patents are driving a lot of value for companies, and because everyone can bring out the same technology and present the same features, people want to own each of those individual features, because the user experience is really what's differentiating one mobile device from perhaps another. The quality of the camera may not drive purchases as much as how a phone is unlocked or the user experience. And so what we're seeing is companies ramping up with large numbers of patents, and then using them to try to push and claw at that market share and hope to build the market share using patents as a deterrent or as a way to push people out.
Now, the concept of mutually assured destruction is one that I brought up a while back, years ago, because I didn't think really large tech companies could successfully sue one another, only because the patent portfolios of these companies are so deep that if they started to go down that rabbit hole, they would never be able to claw their way back. That's what I thought.
Right.
And obviously, that's not the case. In the last couple of years, we've seen some of the largest companies go after each other. So what's happening there?
Right. It's really interesting, because some of the largest companies in the mobile telecom space weren't in the mobile telecom space 3 years ago, 4 years ago,
right.
5 years ago, and so you have companies who were in the mobile telecom space that have been pushed out almost, and you have new companies rising, the Apples and Googles of the world, who that wasn't their traditional models, being in the telecom space. So while they may have a number of patents, they don't have a number of mobile telecom patents, and so you have companies that used to be market dominants still in the market, but trying to claw that market share back of the up-and-comers, and so I think you'll see a big change as we move into LTE, and more companies invested heavily in patents in that area, and I think you will see a little bit more of, well, we have some, you have some, and let's debate.
More cross-licensing then.
Right.
Like the way things used to be. Okay.
Right, and you can see Google, purchased Motorola Mobility, so they brought themselves up, and they're, each of these companies is starting to add more and more and more. You can see in the Apple versus Samsung case, Samsung has turned around and filed suit against the iPhone 5, and so now here they are racing back in. Why? Because Apple's using LTE technology.
Sure. And they threatened ahead of time. I think it was at least a couple weeks ahead of the launch that they would sue.
Indeed.
And I think they added were there 4 new patent infringements that I think?
It sounds right. I would have to go back and
okay, a number, I guess,
yeah,
a handful of.
But again, you're looking at companies that sort of pre-positioned their patent strategy into LTE and waited for companies to move into that space. And I think you'll see things even out a little bit more, because people who invested in 3G may not be as big a market participants as maybe the 800-pound gorillas in the room. So it's quite interesting.
So for some of the small to medium companies that don't have teams of patent attorneys, what are some of the pitfalls that you've seen them make and some things they need to avoid?
I think the biggest thing is thinking on the scale of these other companies. I think the mobile patent wars, if you look at the companies that are involved, you just need to put that aside and realize that they might have 100,000 patents, they might have 1,000 patents, but there are 4 patents that's in the suit, right? And so for a small to medium-sized company, you don't need to be scared away, oh, I need to have 100 patents. You need to think about, what are my 1, 2 patents? How can I protect my sales? How can I protect my devices? I don't need 100 to take down the giant, I just need 1. And so I think a number of people are scared off because they think, I can't get in because my whole spend will go out the door. I think 1 or 2, investing in their research and development, following that up with patent protection, will not break the bank. And allow them to be a participant and allow them to then defend themselves.
Now there's another group of companies that rely on patents to generate revenue exclusively, and
right.
They're referred to potentially, depending on who you talk to, as maybe patent trolls,
right.
or I guess that's the most common term. What are your thoughts there?
A patent's a property right, and someone has paid to obtain the property right, and I think since they own it, they should be able to assert the property right. And most of them are patent aggregators and build families and try to drive funds to those inventors that built the patents. So, I don't know that patents as a business model alone, just for someone's personal wealth, is what our system needs to continue to support. And I think the changes in the law have helped curb that. But I do think that companies that try to buy patents and have some royalty streams going back to the people that couldn't monetize them, I think are helping the process.
Well, I think you explained it well. I mean, it's someone actually worked to develop that patent, assuming it's a good patent and
right.
It was something that was innovative and it was awarded correctly, that there should be some monetization allowed.
Right, and I think it's hard that the term patent troll or non-practicing entity has a derogatory term, and I think it's because there are people out there who use it as a shakedown or licensing. They call it licensing, but they're really threatening. I'll sue if you don't do this. But I think there's other companies that have artfully built portfolios and are trying to monetize them for themselves and on behalf of inventors, and I think there is a difference there. I don't know where to draw the line, but I think you know it when you see it.
So now, if a company is interested in learning more about how they can protect themselves or to get advice on how to make sure that they are dealing with patents correctly, how would they reach your firm and you? And
well, we're available. We're Alston Bird. We're at alston.com, and we'd love to talk to anyone who has questions. And I think the most important thing is to be educated about the patent process. And the Suits Conference and IT Expo provides that education. And any law firm that you hire should provide you with the education as well as the services to obtain the patents. The hardest thing in the patent field is understanding how to navigate it, and once you do, you feel very empowered and you can make good business decisions without spending your entire budget.
Excellent. Thanks for being here.
Yeah, thank you very much.
This was great.